Hello, I'm Jeff M. Brown, the legal writer for the State Bar of Wisconsin. Wisconsin is one of 17 states that continues to allow the indiscriminate shackling of children ages 10 to 17 during appearances in juvenile court. The Wisconsin Supreme Court has a chance to change that when it hears arguments on a petition that would establish a presumption against the shackling of juveniles. Courts would retain the authority to order a juvenile to be shackled where necessary to maintain order and safety. With me today to discuss the petition are lawyers who regularly represent juveniles, Eileen Fredericks and Alaina Fahley. Welcome, Eileen and Alaina.
Thank you.
Thanks for being with me today. Can you talk a little bit about why each of you supports this petition and why it's a good idea?
Sure, I can start. So I've been working with kids for a long time, and this has always been something that I have really not liked, is that kids can't write. Once they have their hands shackled, they seem uncomfortable. Parents are upset and crying. The kids ask about it. And so this has been a long kind of a quest of mine to get rid of this practice in Wisconsin. I do a lot of work with the National Juvenile Defender Center. I think it's actually changing their name to the Galt Center here very shortly. And they have been working on this really for the last decade, trying to make changes across the country. And Florida, I think, was the first one to do it in 2010. And then there's been a lot of action across the country and different states making some different efforts. And my boss here in Dane County tried to make a change against it in, I think, 2014 in Dane County, and it took a while before we were actually able to get to a place where we felt like it was a good policy versus a policy that was very onerous and difficult for us to even hope kids would be unshackled. So just because of fairness, because I just think that shackling kind of invites dysregulation. Kids can be appropriate in court. There isn't a need for these kids to be shackled. It doesn't give them the opportunity to show that they can control their behavior and that they can, be polite and appropriate in court. I just think it's totally unnecessary in most cases. So I am so excited about this petition. I am so hopeful that it actually is successful. I think at different times I've worked with different lawyers around the state trying to make changes in their county, but with 72 counties, it's a lot of work to try to go county by county. And, it's hard from Dane County after we got this moved to really, get somebody who has the time to kind of push it through in their counties. We have had some progress and some successes, but I definitely think the Supreme Court rule is the way to go. I mean, I think this is important, and I think that it's just not practical for us to go county by county, and it should be a statewide practice that kids don't need to be shackled unless, there's a really clear safety concern for them or for somebody else.
Thanks, Eileen. What about you, Alaina?
Thanks. I have not been doing this as long as Eileen, but during the period of time that I've been working with kids, I think shackling has been a very clear issue that has really been a case by case or county by county set of justice for these kids. When we're working with kids, usually if they're represented by public defenders, they're 12 to 17. But we sometimes see kids that are even younger than that. And when they're coming into court, they're shackled. And sometimes their feet don't even reach the ground. It can be really, really dehumanizing. And what I've seen is an impact on my clients along with their families. And I think that what I've seen in my practice and in the area I practice in multiple counties is that there is a presumption that if a child has been determined to be placed in secure detention, which sometimes occurs on an intake decision prior to even having a judicial review, that somebody else must have made a decision that this child is dangerous and therefore they need to be shackled. And I think that it's sort of a paradigm shift that kids are being traumatized when this is happening, and there's not most of the time there's not really the true safety concern. It's that there's already been this label that somebody's decided that this kid is dangerous, and we're not giving them the chance to prove that they're able to cooperate in court. And what I've seen is that while the judges have power and have the decision-making ability to allow our clients to have that experience where they can effectively assist in their representation and effectively participate in court, a lot of times they're deferring to somebody else's decision, and sort of the same thing that we hear a lot of times, which is, this is how we've always done it. This is how it must happen. And I think our challenge here is to say that that's not the case. We know from our work with the soon-to-be Galt Center and Eileen's work nationally that there are other places. There are 5 counties here named in the petition where that default of shackling a child who is coming into court, who's in secure custody, doesn't need to be the policy, and actually is harming our children.
And Alaina, what county do you practice in?
I practice in a few different northeastern Wisconsin counties. Primarily, I am located in Appleton, so I work in Outagamie, in Brown, and in Calumet.
I was born in Appleton, so I know that area. I know that area well. So just to be clear, when we're talking shackles, are we talking handcuffs? Are we talking ankle restraints? Other sort of things? What exactly is it, or does it depend on each person?
It is county by county, I think. So I don't think it's like dependent on like the kid, but it is county by county, which also I think kind of talks about, like, shows that there isn't necessarily this like universal idea of like what safety means. So there's some counties that actually shackle kids to the floor with ankle shackles. And then there's kids who have belly chains. There's kids who have handcuffs. I know that some of the counties that are kind of slowly adopting this whole idea have like taken off handcuffs, but still have the ankle restraints. I've had people talk about kids like almost, falling on their faces because they're trying to walk with these chains on their legs. So.
Well, and that's why I asked, because when I heard the word, when I hear shackle, I think manacles. I think something more than just handcuffs, right? And as someone who was a lawyer but never really practiced, certainly criminal law in the courtroom, I leap to images from popular media, right? And I think of that movie, The Rock, with Sean Connery, and they bring him out. You don't see his face; you just see him walking, and they've got these manacles and these chains on him. The filmmakers did that to make the point: this is a bad dude, right? This is a dangerous guy. So the notion, and that's just a film, right? But the notion that children indiscriminately, ages 10 or 12 to 17, are similarly lashed up just as a matter of course because of habit was really surprising to me.
And I would say even just recently, within the past few weeks, I have seen clients who are shackled using handcuffs, and that the handcuffs are usually connected then to a belly belt and leg irons or leg shackles.
Sounds medieval as someone who hasn't seen it. The petition talks about some of the effects that shackling has on children. It talks about shame inducement and the fact that gets in the way of the rehabilitation. Can you talk a little bit about how you've seen it play out with some of your clients and what effects it's had on them?
Yeah, I mean, I see at kids like a lot, like there's kind of like really like down, and then they'll be asked a lot of questions like ahead of time about like, well, why do I need to be shackled, and like how will I be shackled, and well, what if they're too tight, and I've seen them have like kind of physical marks on their wrists from them being too tight. I do just feel like the difference between when we used to shackle and now in Dane County where we generally don't is just that kids just, sit up straighter in court, and they just seem like they're more engaged and they can listen better. And some kids are like asking to have a pen and will like write me notes. But before it was like, I couldn't even have them hardly write anything or even sign something if I needed them to sign it because they'd have the shackles. I think that it's just like for them, they feel, just embarrassed and ashamed. But I've also seen trauma responses from kids because, I've had kids, and one that's actually very notable in my memory is a kid who had a lot of physical abuse in his history. He had a mom's partner who had physically abused him for a long time, and he had the shackles on in the belly chain, and he had the shackles, attached to the belly chain, and without like kind of letting him know that they were going to be like grabbing the belt behind him. They were like ushering him into, back out of the courtroom, and they like grabbed that, and he like basically like jumped and then kind of had this big reaction. And the judge later was kind of like, oh, well, this is not the way that you should be reacting. And I'm like, that was the trauma response. I mean, that's like somebody coming up behind him and abusing him, and then him having that similar feeling when you just did that, which you wouldn't have done if you didn't have that belly chain behind him. I mean, maybe they would have like ushered him, but like he would have expected that, and it wouldn't have been this like jolt to his whole body. So just like that was a huge, like, I think light bulb for me of just like how difficult this is for some of the kids. I think that even just with all the racial issues that we have in this country and in the state, like the kind of the visions of slavery, it's just awful. It's awful. I just really think that, there's just not a need for it. I think that the counties that are doing it without shackling are seeing that. And I don't think, I think, Florida has big cities like Miami, and they're able to not have their kids shackled. If Miami can do it, I think every county in Wisconsin can do it.
What you, Alaina?
I think I've definitely seen a lot of the things that Eileen is talking about. And I think there's also a procedural justice concern that comes up. So when our clients are coming in and they are 12 or 13 years old, and this is the first time they're in court and they are shackled in so many different places, there is the shame that you had asked about that I think is coming, but it's also sort of this idea of a lot of times the shackling is occurring for their detention hearing, for their initial appearance. And so I've even had clients say, why am I here? Why am I going to have a day in court and have a court trial or a fact finding in front of a judge? They already think I did this. They already think I'm horrible. They already think I'm a monster. And so when I have clients who are not shackled, there, I think, is more of a perception and a reality of fairness, that when they're able to fully participate and they're not focused on the physical harm that they're receiving or even the psychological harm that this is doing to them, I think they're able to participate better. And I think that it also shows I believe that there are studies out there that show that that just stepping foot in a courtroom is potentially leading to there being more involvement in that court system for that child. So the more restrictive we make that court system, the more likely that kid is to come back in. If we can be looking at kids and giving them the opportunity, I think they can rise to that occasion. And I think that that's what we're not allowing them to do when there's this presumption for shackling.
Well, it's interesting you mentioned the reaction to, they already think I did it. You
Yep.
said in the words of one of your clients, and it's almost as if the presumption in favor of shackling is standing, opposite the presumption of innocence, which I assume applies in juvenile court the same way it does in criminal.
Absolutely. So in Ray Galt, so the Galt Center that Eileen had mentioned, in Ray Galt is the constitutional case that provided that juveniles have the same constitutional rights as adults. So that youth have those same rights.
You've mentioned, and the petition mentions this sort of patchwork of regulation we have among the state's 72 counties. Some there's a presumption for it, some there's a presumption against, some are mixed. I have a map that someone at the state bar made, and different color for each one of those categories. And then there's some counties which are bicolored with chevrons because it's a mixed court by court. What kind of problems has that patchwork caused for your clients in your practice, if any?
Well, I think actually Alaina might be able to answer this because I think it's just like, she works in different counties, but I mean, for the most part, I hope kids are not like experiencing court systems in different places just because you wouldn't want that to be their experience. But I just think that, generally speaking, if you think about it as like a fairness, and kids are fairness fanatics, right? They care about fairness, like that's what it should be. So Alaina's already talked about how they feel like they're, already found guilty, but just the fact that where you are like makes the difference in terms of like whether or not you're treated with dignity in the courtroom or whether or not they just assume that you're, unsafe and that they have to, if you weren't shackled, then you would do something, inappropriate or, even more so dangerous. I think that that's like a huge problem. It just, there doesn't need to be that disparity across the state. And that's the reason for the rule. I mean, there's still going to be some obviously discretion by some judges who are going to be very liberal with the rule and be like, well, I just want to err on the side of safety. And I'm worried about that, but it's at least a universal idea that like the presumption is against shackling, that most kids can be okay and be appropriate. This is not like about punishment. It should not be about punishment. It should be about safety. And that should be probably like the lone concern. Are they going to take off? That, is also a concern, but there are definitely ways to, reduce the risk in terms of those things without shackling. And I don't know why we can't, get on board for everybody across the state. I don't think that like kids necessarily are aware that, in Dane County, I wouldn't be shackled. We could be telling them that just to kind of like, we don't want them to feel like the process is unfair either, right? And that's what Alaina was saying about procedural due process. Their respect for the court system is, going to be decided as for their whole life, probably if they are in court as a juvenile. And if they feel like I wasn't treated fairly, the court system isn't fair, people don't follow the rules, people don't do things just because it's the way they always did it and not because there's a good reason for it, then that shapes how much respect they'll have for the court system and how they'll kind of move forward from there. So I just think, and of course I'm biased, but it's like a no-brainer that we need something that just kind of across the state says, this is what, the doctors say, this is what people have seen in court. This is not necessary. Let's not do this. It's not good.
Right. And again, it's important to point out it would be a presumption against, but a court could still order it where necessary for order, decorum, or safety. Alaina, how about up there in your neck of the woods? Is it all the counties you're in the same, or is it different county to county? And if so, how's that affect?
No, it's different county to county. It's different sometimes judge to judge. And I think that this Supreme proposed rule empowers judges to make that decision, because I think what I've seen is there's really a deference to somebody else making that decision. This is how we've always done it. This client has been deemed to be placed in secure placement, therefore we must shackle. And I think it empowers the judges to look at these children as children. And what happens, I think Eileen is right that perhaps my individual client is not seeing, hey, if I was in this county, I wouldn't be shackled, but I'm shackled here. But I think enough families have experienced children in multiple counties. I think that enough children have maybe talked to other friends that may have been through the system. And I think even if we're not telling them, or if they're not seeing it and experiencing it themselves, the idea that there is different justice depending on what your zip code is or what county you're living in, again, the fairness fanatic, it's not fair, and it doesn't seem fair for these children. And I know that I have clients who are aware of that. We have limited resources on secure placements. And so there are children who end up in secure placements that are from a variety of counties. And they may be talking to other children who are in that placement and hear about, well, I don't have to have this happen to me. And if you're hearing that as a child, what does that mean? What does that mean about me if I'm being shackled, but this other person isn't? What is it? Because I think kids internalize that. And I think families internalize that. And I think that's where that trauma comes from.
Do you both do adults as well, or just juveniles in your practice?
I represent the age spectrum.
And I ask because I'm wondering, are adults who come out of jail for hearings, are they routinely shackled?
I would say yes.
Okay.
But I think kids are different, and they're different for a reason. I think there is harm to adults as well, but there's actually a Wisconsin case that is cited, I believe, in the petition that says that the same decision-making power lies in in the judiciary for adults. And so there's still the idea that every adult and especially every child should be treated with dignity. So while there is a lot of concerns that we may have for adults who have those same concerns, kids are different, and kids, I think, are receiving this indiscriminate decision differently than an adult would.
How about you, Eileen? Any similar thoughts on that?
So I represent mostly kids, but I do think, with kids, they can't post bail, like if they're held in detention, they're held in detention. There's no way for them to get out. So I think that that's like one difference. And then, yeah, I think that like kind of their emerging identity is something to be thinking about, right? Like with adults, I think, sometimes they have had a chance to kind of develop and decide who they want to be and internalize things about themselves that kids just are still trying to figure out. So when we're internalizing for them that they're dangerous, that they can't manage their own behavior, that, if they didn't have these shackles on, people would be concerned that they would be out of control. Like that's not something that we should be trying to reinforce in these kids at all. So I do think that that's why there's a push, really regarding kids, nationwide as well as statewide.
Okay, great. Well, thank you both, Eileen Fredericks and Alaina Fahley, for speaking with me today about the petition before the Supreme Court to enact a rule that would presume against shackling for juveniles. We'll see what happens with the petition and whether the court takes it up. Thanks again for your time.
Thank you.
Bye-bye.